So I've hit the recording button. So I'm recording the session, and I'll provide some information about where to find the recording if you want to revisit it or view it again at a later date. Just so you know, if there's any questions, hopefully there'll be time for a Q&A at the end. But if you've got some questions, in your GoToWebinar control panel, there should be a questions section. You type your question in there, and then I'll pick it up at the end. Thank you very much for joining me this afternoon for a webinar about GDPR and Brexit, which I'm sure are the two favourite topics at the top of your list of things to be thinking about in your organisations. But just to introduce myself, my name is Mark Gracie. I help businesses with their GDPR compliance. I do that primarily through a helpline service, which is unlimited email and phone support backed up by online resources. And I'll mention a bit more about that towards the end. But I do other things as well: outsourced data protection officer, reviews, audits, policy development, and training, etc. My background is very much in the regulatory space, having become a data protection manager back in the late 90s when the 98 Act in the UK came into play. And I've been involved in regulation and data-related regulation almost ever since. So anyway, that's enough about me. I'm going to cover a number of different things. Obviously, the main feature is about GDPR and what that might look like once we've properly left the EU. We obviously formally left at the end of January, but we're in this transition period. So what GDPR will look like from basically next year onwards, with the UK outside of the EU. I'm going to quickly introduce international transfer basics from GDPR and what the GDPR says about processing data outside the EU. So we sort of set the baseline for that. Look at what the transition looks like, which will be a quick slide because it's good news at the moment. And then looking in a bit more detail about some of the challenges and what post-transition GDPR might look like in the UK. So first of all then, we're obviously talking about the General Data Protection Regulation. It's an EU regulation that applies to all member states and has been in place, believe it or not, nearly 2 years. In May 2018, it came into force in the UK, as it did across the whole of the EU. And of course, we were already in this process of the government trying to sort out leaving EU, but because GDPR was into play before we'd have formally left the EU, it's obviously part of our law right now. We have the Data Protection Act 2018, which essentially sort of implements that into UK law, as well as some of the derogations and bits where member states can have some control over what they allow under law. But basically, we're working to GDPR right now, and so let's just run through some of the basics about what happens or what GDPR says about if you want to process data outside the EU, because obviously that will become apparent when we've left the EU. The UK will be outside the EU, and therefore there's some considerations for processing data in the UK once we've properly Brexited. So the GDPR essentially says all EU data should be protected. So if you're processing personal data relating to EU citizens, it needs to meet GDPR level of compliance and protection, and that any transfers or processing of data outside of the European Economic Area, which is the EU plus some, EU member states plus some extra countries, then there is very much some restricted controls around that being allowed. And of course, we typically talk about what do we do if we process data in the US, or if we are using, say, an Asian call center and we share data or allow the Asian call center access to our customer database for customer services or whatever, then of course where they are using or accessing that database from the Asian call center, they will be processing data outside the EU. So it's that kind of thinking. But simply, if you want to process data outside the EU, outside the EEA, then those are called restricted transfers, and there's controls in GDPR about what you must do to allow that to happen. And then there's some additional provisions which we'll talk about probably throughout. So things like if you aren't domiciled in the EU, but you target EU citizens, then you'll potentially need EU representatives, so somebody to represent you on behalf of your data protection compliance from within the EU. And typically that's the country, you choose the country where you have most of your customers if you operate across multiple member states. And then there's the concept of the lead authority, or what is also sometimes referred to as the one-stop shop, which basically means that if you cause some kind of issue relating to data protection across multiple member states, so in the sense that you're processing, say, UK, German and French citizens' data, and all three countries' citizens' data is compromised in some way, then rather than you having to deal with both as well as the UK representative, if you're in the UK, so that's the Information Commissioner's Office, you would it means that you don't have to also deal with the German regulator and the French regulator. They basically agree which is going to be, or who's going to be, the lead authority, and that authority then leads with the investigation, the enforcement, any action, would be that criminal prosecution, fine, or whatever. And those are basically a way of knowing that right now you just have to rely on the data protection authority, where you're probably where you're domiciled, although it might be where most of the problems has arisen if that happens to be somewhere else. Our data protection authority, of course, as I said, is the Information Commissioner's Office, the ICO, and this element of GDPR means that you just know you have to deal with one regulator rather than lots of them. So what this means in practice is that if you're processing data within the EEA, so you can pass data to France and not worry, because French businesses are bound by GDPR just as they are in the UK, then that's fine. If you process data outside the EEA, then you have to stick by one of the basically one of the rules that allows you to either transfer data or not. So if you're processing data outside the EU, you can do so in countries where an equivalent law exists, and that means that the EU itself has declared a country has adequacy or adequate data protection compliance. Most recent example was Japan. Japan was declared that in the business-to-business context, for processing data in the purposes of businesses, their data protection law is equivalent to GDPR, and therefore if you want to process your data in Japan, you can rely on the adequacy decision from the EU as your lawful reason for allowing that transfer, so it wouldn't be restricted in that sense. The next thing to consider, if it's, I mean, just going back on the different countries that have adequacy decisions, there aren't very many, I think it's barely 10. There's some, for example, Australia isn't on the list, but New Zealand is. Canada has, sorry, not Canada's a bad example, I'll talk about that in a second. Israel is on the list, New Zealand's on the list, and so on. There's really a small handful of countries that have adequacy decisions against them. For those who don't have adequacy decisions, you then got to decide, well, is there an EU or and that country agreement? And probably the most well-known example is Privacy Shield. So this is an EU-US agreement with an EU agreement with the US that companies who sign up, and it's a self-assessment, a self-signing approach basically to Privacy Shield, then they are applying EU standards of GDPR compliance. There's also a Swiss EU agreement, and I don't know why I got confused with Canada earlier, but Canada is also a country that, for business purposes, has adequate GDPR compliance. I was getting mixed up with the Swiss one. So there's an EU-US privacy shield, and there's an EU-Switzerland agreement. So if you wanted to transfer your data to the US, then US hasn't got an adequacy decision. Therefore, you could rely on Privacy Shield if the US company has signed up and self-certified that they will apply European standards of data protection. If you want to transfer data to a country that doesn't have adequacy, isn't one of the ones that have a separate EU agreement in place, then you have to look at what are the other options, and the only other option really is that there is a contract in place. So there's what's called standard contract clauses, which are defined by the EU in a separate regulation, and you literally have to cut and paste and put those into a contract between the two parties, and you're therefore binding the other party by contract to process data only according to EU standards. Now, I've listed binding corporate rules. This is the green circle on screen. The binding corporate rules is like the standard contract clauses, but they're internal to the business. So if you had say you were a UK company that was actually owned by a Chinese company, and the Chinese company wanted to have access to the UK company's database, then you might look at binding corporate rules. The downside of binding corporate rules is you have to get them approved by a data protection authority, so it would be the ICO in our case, and that can take some time to organise. So a lot of businesses tend to rely on the standard contract clauses. Now, just a little caveat that the standard contract clauses that exist right now and are even being referenced by the ICO's guidance are ones that were put in place under old data protection. So that was the old data protection directive from the EU, which led to our 1998 Act. They haven't updated them for GDPR, so some of the terminology is slightly wrong. And bizarrely, well, I was talking to the ICO recently about this. They sort of suggest that you might want to look at them, but they accept no responsibility if they turn out not to be valid, which sort of puts everybody in an awkward position. But generally speaking, the expectation is if there's no adequacy for the country where the data is going to be processed, there is no separate agreement such as the Privacy Shield for US organizations, or if a US company hasn't signed to Privacy Shield, then the only route is to go down the standard contract clauses or not transfer your data and protect yourself by just not transferring outside of the EU. But as I say, standard contract clauses are usually the one that particularly lawyers like to use because they're more of a binding contract. So that's the basics of what GDPR says about restricted transfers. Hopefully it will become apparent as we go through why that's relevant to the UK in a Brexit scenario. So if we move on to looking at what we can expect or what GDPR compliance looks like this year, so in 2020, well, actually it's quite good news in some ways, in that nothing changes. So even though we've left Europe as of the 31st of January, GDPR still applies because we're in what's called this transition period, which will end at the end of December 2020. And during that period, basically, there's no change. There's no change across anything that's happening between the exit of UK from EU. So everything stays the same, and that's true also for GDPR. So if you should be worrying about GDPR, then you need to continue worrying about GDPR right now as well. But what's going to happen is over this year, hopefully, we'll get some clarity about what happens from next year. So post-transition, when the transition period ends, and of course, if the transition period happens to be extended for whatever reason, then there's a chance that things won't change with GDPR until the end of that transition period anyway. But you do need to pay attention, particularly if you're impacted, and hopefully the slides that are coming will give you an idea about whether you're going to be impacted or not. If you are impacted, then you'll need to think carefully about in what way you're impacted, and pay attention to any announcements that come out from the government or from the Information Commissioner possibly even EU guidance that will help us understand how the GDPR process will work in a basically post-Brexit UK. So let's move on to, as I say, good news for 2020. You don't need to worry about things too much because nothing's really changing, but obviously you do need to worry about GDPR generally. But if you are impacted or are likely to be impacted post-transition period, so after this year, then you need to pay attention to what happens next after that. So once we've ended the transition, which is likely to be from 2021 onwards, then you need to understand how that may impact data flows between you and Europe going forward. So let's look at GDPR post-transition, so from 2021 onwards. So the dilemma that Brexit brings to us with regards to GDPR and what it looks like in a Brexit scenario, so UK not being part of Europe. At the risk of stating the obvious, we will not be part of Europe, and therefore any transfer to the UK from Europe, from a European country governed by GDPR, will be considered a restricted transfer. So then if you remember that slide we were just talking about some of the GDPR rules around restricted transfers, you then got to think, well, are we likely to get an adequacy decision? So this is something that might happen in the rest of this year, is we might end up with the EU agreeing that in the UK, because we've had GDPR for essentially just over 2.5 years, we may as well have an adequacy decision. But I've just thrown in, as you'll see there on the slide, that it took 1.5 years from the EU announcing it was going to work with Japan on its adequacy decision to actually get to the adequacy decision in the end. So there is a question around, even if the EU are happy to accept that the UK has equivalent law, the adequacy decision process, unless it's sped up in any particular way, might not get sorted out within the transition period, and particularly if the transition period is going to be taken up with lots of other things like trade negotiation deals and so forth. So there's a question about whether we will get an adequacy decision which will say it's okay to pass data to the UK because they apply GDPR level of compliance. And just to clarify, because people often think, well, why wouldn't we have adequate? The point is that even though we're living with GDPR right now and have done since May 2018, in the eyes of the law, because the UK is no longer part of Europe, we would not be seen to have adequate data protection unless it's being tested. So it seems a bit silly to think, well, we're living with GDPR, everybody's working towards GDPR compliance every day, and yet actually the technicalities of GDPR say that that doesn't matter. There needs to be a formal process to go through down the adequacy decision route in the first place. So if we don't get an adequacy decision either straight away or not at all, and I have heard rumours in the past that the UK might struggle to get an adequacy decision because the EU or member states tend to not like the way the UK government implemented some data retention regulations that typically affect the telecoms industry and internet companies. But there is a piece of legislation that basically says that your telecoms provider has to retain data for a certain period of time, regardless of whether they need that data or not, just in case law enforcement need it for investigation of crimes, terrorist incidents, security-related things, and so on. And whilst that's based on a European directive, the UK have implemented it in a particularly sort of strict way, which it has been commented that the EU don't like. It's even been challenged at EU level as well. So, whilst I say we may get an adequacy decision, there's always a point that the EU could turn around and say, well, if only it wasn't for your data retention directive regulation, we probably would have given you an adequacy decision. So there's always a chance that we might not get an adequacy decision, even though it looks like we ought to. So if we don't get an adequacy decision, what are the other options? Well, there could be a UK-EU privacy shield type agreement, perhaps, which means that we might need to look at, if you are processing EU citizens' data, then you might need to sign up to that in the same way that Privacy Shield works at the moment with the US. But again, we'll have to wait and see whether that's an option. Failing that, and the circumstances when essentially if nothing happens, so nothing gets sorted out about GDPR in 2020, then we will be as though we've left Europe without a deal, or where things would have been. So if you've attended any of my webinars in the past about Brexit and no deal scenario, that kind of scenario could still apply. But no adequacy, no agreement, the only option then is to fall back on standard contract clauses. And I've already been working with organisations for the on and off over the last year or so, usually peaking around when we thought we were going to be leaving Europe last year, so sort of March time, and was it October? Businesses pushing UK companies to sign standard contract clauses just in case there's a no-deal Brexit. So we might see, or you might see, if you have dealings with EU companies or EU citizens, that you might be pressurised into signing standard contract clauses, regardless of what might happen or fall out of the GDPR and the EU-UK Brexit negotiations in the transition period. At the risk of sounding really vague, there's a possibility that something else might happen. You know, something the EU might agree on some other terms, or something else might happen, or there'll be an extension. You know, one option could be, for example, an extension of the transition period for GDPR purposes. So we're given a grace period for another 2 years while an adequacy decision is sorted out, or something like that. I mean, I've not heard any noises along those lines, but you know, there's always potential for something else. So it's a bit of a dilemma. From a Brexit point of view, even though we're living with GDPR, we will not be considered part of the EU, and therefore any transfer of data to the UK from the EU will be considered a restricted transfer. So we need to think about these GDPR elements of either adequacy agreement or the model clauses or the standard contract clauses. So looking at it going forward, we do know some things. We know that we will have, at the end of the transition period, what is being termed UK GDPR. So we will be talking about EU GDPR, which is what applies across Europe, and UK GDPR, which is the GDPR that applies in the UK, which for all intents and purposes will be the same as EU GDPR, but we will need to at some point possibly start differentiating between the two. But we will have a UK GDPR, which basically implements European level GDPR, just as we have today. In UK law, and that is going to be supported probably by a Data Protection Act, maybe the 2018 Act, or maybe they'll do some other updating and we'll end up with a Data Protection Act 2020 or 2021. We're not expecting to see any changes with data protection compliance in the UK, so certainly don't think because we're leaving Europe you don't need to worry about GDPR anymore. That's not going to be the case. There has been commitment from the UK government that the ICO will continue to be the regulator and the lead authority in the UK for data protection compliance, along with the other things it already does. So things like the e-privacy and freedom of information and some other regulations that they uphold as well. So yeah, so for sure, don't think that GDPR will be changing, because it won't be anytime soon. But sort of an unknown that we do know is that there's likely to be changes if you're acting as a data processor from the UK, processing EU citizens' data, or if you target EU citizens, whether you've got a presence in an EU country or not. And so I'm going to talk a bit more about that and what that means in a second. So essentially, we're looking at the situation that from probably next year, obviously if the transition period gets extended, then it'll be whenever the transition period ends, that we're either going to end up with a situation where some kind of agreement has been arranged with the EU, which will make our lives probably a lot simpler, or we go down the route of there is no agreement with the EU, either at the end of transition or you know, potentially into the future, depending on whether something runs over or whether they plan to do something at a later date. But if we go down the no agreement route with the EU, it will be the equivalent of what we in the past have spoken about in terms of what GDPR looks like in a no-deal Brexit scenario. So that was when we were talking about no withdrawal agreement. We'd be cut off immediately. We're not being cut off immediately. We've got the transition period, but if there's no agreement, then the outcomes are essentially the same. So let's look at that in a bit more detail. If we end up with some kind of arrangement or agreement with the EU, then if you operate only in the UK and you only process personal data relating to UK citizens, you don't need to change anything. You still need to apply GDPR, whether it's the UK GDPR or the EU GDPR, but there will be no change in what you do with regards to data protection compliance. If you pass UK data to the EU, then the ICO and the government have basically said they won't prevent that. So from a UK data transfer or restricted transfer process, there will not be a UK organisation passing data to the EU. EU will not be seen as a UK GDPR restricted transfer in the same way as if you were passing data or processing data in the States, which would continue to be a restricted transfer and would require on Privacy Shield signing or the standard contract clauses, for example. So if you're operating purely in the UK and only process UK data, you're not expecting to see any change. If you only process data in the UK or within the EU, so it's UK data in the EU, then there's probably not going to be any change. But if you are processing EU citizens' data within the UK, then there's going to be whatever the agreement reached presents in terms of whether that's an adequacy decision, a agreement of some kind, or something else. So relatively straightforward, although there is that unknown about whatever that agreement might look like, will determine what you do if you're processing EU citizens' data. And your biggest challenges will be if you're operating in the UK and you're either processing data according to EU citizens, processing data as a data processor on behalf of EU organisations. So you might be a UK marketing company and a French company asks you to process their data for some email marketing. That would make you a data processor, and you'd be a data processor outside the EU. And the other scenario is if you're targeting EU citizens. So this will all depend on what agreement is reached. So slightly more straightforward in the sense that there's only 3 bullets there, but there's still that unknown about, well, it depends what the agreement says. Yeah, either way, you need to basically pay attention if you are going to be impacted post transition. So if we end up in a situation where no agreement is reached about GDPR with the EU for whatever reason, then it is, as I said, going to be just like a no-deal Brexit would have been. So to summarise, and those bullets on screen there sort of cover all the hopefully all the different scenarios. The only one I've not put on there is if you are doing what is currently a restricted transfer, so you're processing data outside the EU, say the States or Asia or a country, then the same rules will apply from within the UK, even when we're outside the EU anyway. But looking at this from a different scenario situation, so if you're operating purely in the UK, nothing will change. So that's no different than the previous slide. And likewise, same with the previous slide, if you pass UK data, so that's data about UK citizens, to the EU for processing, then there's probably not going to be any change, because the UK government have indicated that they would be happy that they trust EU to be compliant according to UK standards, which of course is a reasonable thing to expect, because we're all practicing GDPR across Europe at the moment. Now, if you're a data processor of EU citizens' data, so an EU company wishes to send you some data in the UK, and you are going to be processing it on their behalf, making you a data processor. That transfer for the EU country will fall under the restricted transfer rules, which means that the only appropriate safeguard that's going to be available in a no agreement scenario is you'll have to rely on standard contract clauses. So if you are processing EU citizens' data as a data processor, then you will need to think about what those standard contract clauses might look like. Now, the obligation is going to be on the controller, who in this scenario will be in Europe, but that doesn't mean that you can't preempt their need. But it also means, as I said before, I've already seen businesses who have been pressurized into signing standard contract clauses before we'd even had a withdrawal agreement agreed or not agreed. So that's something to look out for. If you sell products and services to EU citizens and you don't have an office in the EU, so what that means is you're operating from the UK, but you're selling products and services into the EU, then you will be bound by both the UK GDPR and the EU GDPR. It also means you will be therefore answerable as a UK entity, answerable to the Information Commissioner's Office. But if you infringe the rights of an EU citizen in an EU country, then you'll also be answerable to the EU regulator. So going back to what I was saying before, when we were talking about the sort of summary of what GDPR says, if you infringe data in France and Germany, then the French and German authorities will determine who's the lead authority, and then you will have to deal with the ICO, who might look upon you as breaching UK GDPR on the basis that you've caused some breach with European data, and you'll also have to deal with the French or German regulator as the lead authority there. So you will essentially find that you will not be able to make use of the one-stop shop. So this concept of only having to deal with one regulator. And you will need to have an EU representative. So that will be somebody domiciled within one of the European countries, typically the country where you have most customers or most people that you interact with, and they will have to represent you as an EU representative for your data protection compliance. And there are things like rules, so you can't have a European data protection officer acting on behalf of you and then ask them to be the representative. It has to be a separate entity as well. So yeah, so if you're selling products and services into the EU, you'll be processing EU data. So you therefore are answerable to UK and EU GDPR. You'll also be answerable to the ICO in the UK and a regulator or potentially other regulators across Europe. And you may need to have an EU representative, somebody representing you across Europe on behalf of your GDPR compliance. If you're I put multinational there, but what I mean is you have offices in the UK and EU, then UK and EU law will apply. And again, you are going to be answerable to ICO and the EU regulator, but you, depending on where the infringement happened, whether it was in the UK or in one of the EU member states, will determine who would be the sort of lead part of your business that would be dealing with the regulators. So if the ICO decided to take action because you've infringed the rights of UK citizens as well as French citizens, then you'd be answerable to the ICO and CIL, which is the French regulator. And you would be answerable as two separate entities. So you wouldn't necessarily need to think about being an EU representative because you have a representation of yourself in Europe. So if you're a EU company and you're passing data to the UK, sort of potentially stating the obvious, you need to look at this sort of the reverse way round. So EU data being passed to the UK will be seen as a restricted transfer, which is why we've had the conversation about what the agreements and terms might be through the transition. So those EU countries may need to consider how they're going to get contracts in place or whatever, depending on what happens in the transition period. But also there is talk that they may need to have a UK representative. So if you've got a favourite client who operates in Germany, there's a possibility that if they pass you data, then there's a chance that they will need to not only pay attention to the fact that post transition, their data transfer will be restricted, and whatever rules are in place, so under contract clauses or otherwise, will need to be put in place. But they may also need to employ somebody who can act as their representative in the UK in case they infringe UK citizens. UK citizens' data rights. So sorry, I don't know, I might have mixed that up a bit. What I mean is, if you're a EU company operating or targeting in the UK, then so it's not about the restricted transfer bit, it's more about the fact that you might have to have a representative in the UK to represent you for data protection under UK GDPR, as well as your own representation under EU GDPR. So apologies for sort of the mix up there. So just to clarify, if you're an EU company passing data to a UK data processor, that will be a restricted transfer. If you are an EU organisation targeting UK citizens, that EU organisation will possibly need to have a UK representative, as well as consider the implications of how to operate under two GDPR regimes, UK and EU. There are some other things to consider, and this is only something we're going to find out over time, be that through the transition period or whatever agreement might be reached, if any, or over time. So there are some questions, there's quite a few questions here about, well, even if transition gets sorted out, what if the UK introduces new data protection laws? I mentioned the Data Retention Act before, and how that has been controversial because of the way UK have implemented it compared to what the European directive or the EU believe their directive was supposedly setting out as the rules. What if the UK goes off on a tangent and becomes, I don't know, slightly more robust in a particular area, or a bit more lax in a particular area that contradicts the EU? Does that mean that we'll lose any adequacy if we got that, or does that change the impact? Equally, on the other flip side is, what happens when GDPR Mark II comes in EU? And I'm just calling it that. I've not heard any rumours that we're going to get a new GDPR across Europe, but and this is true for any European regulation going forward. We still have that close association. There's a lot of European law in the UK at the moment, and during transition that's staying the same, and probably initially it might stay the same as well, or some areas might change quite quickly. But from a data protection point of view, what if the EU introduces new GDPR rules? What will that mean to how the UK operate under that new regime? Will that mean that the UK government will update according to European standards? You know, do you pay attention to what the ICO is saying? Do you need to pay attention to what a regulator in another member state is saying, even when we're outside EU, and so on? So there's still quite a lot of mess that needs sorting out. And then there's this question of the privacy regulation. So depending on whether you've been following the debates around that, the original concept of, so we have the Privacy and Electronic Communication Regulations 2003, which is based on a privacy directive, and it controls, amongst other things, the rules around email marketing, direct marketing, and the use of cookies. And there was an intention of introducing a new e-privacy regulation. The fact it was a regulation meant it would have applied across the whole of Europe. And it was going to come in at the same time as GDPR. Well, it never happened, and here we are 2 years on, and they're still debating whether it's going to happen or not. So it may not happen. But then there's this question about, well, if the privacy regulation eventually passes in Europe, is that going to be something that gets implemented in the UK? I think the only certainty we have here is that if it does get passed in Europe, we will probably be past the transition period by the time it's enforceable in Europe. So it will then depend on what the UK want to do, whether they want to change their e-privacy regulations that we've got at the moment, the PECA rules, or whether they implement the European regulation, even though we're not in Europe at that point. So I was hoping to obviously provide some light about or some clarity around what might happen, and I think there is some clarity in that we don't need to worry about anything right now, but we do need to worry about what might happen from next year onwards, or at least after the transition period. But there are some other areas and some unknown answers to a number of complex questions about what the future might hold with regards to data protection in the UK and its relationship with the EU, particularly if you are dealing with EU organisations or EU citizens in sense of processing EU citizens' data. So what should you be doing now? Well, I mean, we're in February 2020. You've probably don't need to worry about this right now, but you certainly ought to pay attention to any updates that might impact any EU and UK agreements relating to GDPR, and one would hope that we would hear about those. I imagine that the significant issues of things like trade and transfer of criminals and police intelligence and things like that will probably get more of the media headlines than data protection, but you can probably rely on the ICO to keep us up to date on what they're doing, although they're not very good at providing tools to enable you to follow them quite closely in terms of when they change things. But hopefully we would get to hear about updates as they happen. Don't think that GDPR will no longer apply. That's something you can definitely do now. There's been quite a lot of misunderstanding, even in the recent months since we left the EU and we've gone into the transition period with quite well-respected journalists and newspapers covering GDPR and the transition period and saying it no longer applies and all sorts of things. So, but don't think that at all. GDPR still applies as it has done since 2018 and will continue to do so as it is until the end of the transition period. So don't think it will no longer apply now or even into the future. What you might want to do at some point this year is look at your data flows and understand where you're going to be impacted. Are you being sent data from Europe? Are you targeting European citizens? What is that going to mean in a agreement, non-agreement scenario? Look at that and think about how that might impact your organization and how you deal with your customers. And some of that might be driven by your customers wanting to get it sorted sooner rather than later. If you are in that situation, I think you want to try and push back as much as possible because anything's likely to happen in the rest of this year. So if you can leave it towards, probably start thinking about it at autumn, then that's probably, we might know a bit more by then. You may need to update some of your documentation and your privacy policies, particularly if they refer to EU law, because you'll need to go forward referring to UK GDPR, or you might be okay if you're talking about GDPR and how it's enforced or implemented in the UK as a generic statement. But if you're making references to EU law, then you might need to think again and update some of your policies, and you might need to update some of the things that you put in your privacy policies, particularly if they change relating to EU citizens. If you've got any other kind of compliance documentation like data protection impact assessments, then review those and see whether they're still relevant under UK GDPR and how they might be impacted by having a UK and an EU GDPR regime. And make sure everybody within your organisation who is dealing with these kinds of data understand some of the nuances that might need to be in place, depending on what you're doing and where that may impact you, regardless of whether we go down the agreement or no agreement route. Okay, but obviously if you need some more information, I've obviously run through this quite quickly, and we've got 50 minutes now for some questions. But if you do need help, if you want to run through how it's going to impact you, then I can help, either that's on a one-to-one basis or through the helpline service I provide. But I have experience of working with businesses who have been under pressure to get standard contract clauses in place, so I understand the technicalities of that and the concerns, particularly from your clients. So if you want to, at any point this year or into the future, need any help and assistance on that, then you can either do that through a helpline subscription, or we can work one-to-one and look at your specific problems, and I can help you get the things in place that you need to get in place. So that leads me to questions. I've got a little question mark on my control panel, so somebody's typed something. So if you just bear with me a second, I'm just going to have a look and see. So if you do have any questions, look for the questions panel in the control panel and type away. I've got a couple of questions here, so I'm just going to quick look at those. Okay, so Stephen's asking, what's the situation if if an EU firm sends customer data to a firm in the UK for processing? So the data controller would be in Europe, the data processor will be in the UK. The company in the UK will need to be applying UK GDPR, which will, for all intents and purposes, be EU GDPR, but is bound by UK GDPR. But the EU firm will need to consider, as we were discussing earlier, will need to consider the implications of the fact that the data they're transferring to the UK will be a restricted transfer. So really the answer to that question, what's the situation if an EU firm sends customer data to a firm in the UK for processing, will really depend on the outcome of any deliberations during the transition period. And going on from that, a further question about what happens if the UK firm receiving the data is going to be a data controller rather than a data processor. I very much suspect that organisation, the situation will still be the same. There will be this expectation that the EU shouldn't be sharing the data with a UK organisation, controller or processor, without making sure that proper protections are in place. And of course, the UK firm acting as a data controller will be bound by whatever the UK GDPR says. But if it relates to EU citizens' data, then they'll also potentially be bound by EU GDPR if that is different. But if it is a French organisation passing data to a UK organisation about French citizens, then there is a risk that that UK business will be, if something bad was to happen, whether a controller or processor, be answerable to the French regulator as well as the UK one. Okay, so I've got another question which I just need to have a think about. Just bear me a second. So the question I've got been posed is a very good one. How does this all impact the transfer of data between Gibraltar and the UK? Now, excusing my potential lack of geography knowledge in this thing, I understand Gibraltar is a British overseas territory, and is I'm just wondering whether if it's governed by UK law, then it will be covered by UK law. So Gibraltar to UK data transfers, if I'm understanding this correctly, will be considered an internal UK transfer, so wouldn't be covered by any of the complexities of it was an EU to UK transfer. If I've misunderstood, so this is Sue asking, if I've misunderstood the question or misunderstood my understanding of the legal position of Gibraltar, then Sue, feel free to drop me an email and I'll look into it a bit further. But I think my guess would be that the transfer would be considered a UK to UK transfer for the purposes of data protection, unless there is some complexity in law relating to relating to EU legislation and Gibraltar, which is not something I particularly know anything about at the moment, I'm afraid. That was a good question. Thank you very much. Okay, anything else? There's a few other comments and thank yous. Thank you for those. Just give it a few more minutes if anybody's got anything else now. now's the time to ask. Otherwise, we'll end it there. Okay, so another good question from Sue. Where do we find the list of adequacy countries? So these are the countries who the EU have declared as having adequate data protection in comparison, even though they're outside the EU or the EEA. Probably the easiest way to find it, there is a list on one of the EU websites, but probably the easiest way is go to the ICO's website, go to the GDPR section, and if you scroll to the right to the bottom of their sort of menu on the left of all the different guidance topics they've got, find the international, I think it's international transfers is how they refer to it, and then on that page there will be a section about adequacy, and that should give you a link to the EU page about countries where there are adequacy agreements in place. Okay, so question from Camilla about if you're storing UK data within the EU, for example, in a Republic of Ireland data centre, what's the situation there essentially, and are there any issues? Well, at the moment, the UK government has indicated that if you're passing data for processing, so basically if you're transferring data outside of the UK to within the EU, so a country that's within the EU of the EEA, then it won't be deemed a restricted transfer. So yeah, if you're passing data and it's being stored on a cloud server hosted in Dublin, for example, then there will be no change in that it won't be seen as a restricted transfer. So it will be as you consider it, as though we're in the EU as we are, as we have been, and the same as during the transition period. So at the moment, I don't foresee that there's going to be any particular issues. If you're passing data and storing it in the cloud in the US, then the same kind of rules will apply as they do today. It's just that the technicalities around that might change. So we have at the moment an EU-US agreement, but if the UK are outside the EU, the EU-US Privacy Shield in theory doesn't apply, but I'm expecting the UK government will essentially say for UK to US, you must apply the same rules as the EU to US, but that's one of the things that we'll have to keep an eye out and see if anything changes there. But I certainly from what I've read from the ICO in the past, there's not looking like to be any challenges when it's UK citizens' data being passed outside of UK to the EU. For non-EU countries, then there will be other considerations. Yeah, so sort of a comment, I guess, from Stephen saying, if he's understood it correctly, the situation is that UK will regard the EU as adequate from a data protection point of view, but not necessarily vice versa, which sounds a bit nuts. Yeah, absolutely. I think this is one of the challenge, and possibly for people who aren't paying much attention to it, that they'll assume that everything stays the same because we're with GDPR right now, so why won't we continue to be GDPR post-transition? Well, simply because the law says if you process data outside the EU, of which the UK will be outside of the EU, then you have to have these protections in place, and the adequacy decision requires the EU to make a statement that that UK law is adequate enough. So yeah, I guess a bit nuts is quite a good summary of it. Okay, so some great questions there. Thank you very much for those. Thank you very much for joining. I hope you found it useful. I'll be in touch with a link to the recording and a copy of the slides. If you do find yourself needing any help, then please do get in touch and see where I can help you. Thank you very much. Enjoy your evening and the rest of your week. Thanks. Bye.